The Rules Committee will come to order. We're here for consideration of H.R. 10, the REINS Act of 2011, and the only witness we have here is Mr. Johnson, so please come forward without objection. Any prepared statement that you have, Mr. Johnson, will be entered in the record, and we welcome your testimony.
Thank you. Appreciate the opportunity to be here today. Mr. Chairman, H.R. 10, the so-called REINS Act,
Doesn't work. So.
is not only not necessary, but it's harmful to the public health and safety, and it's harmful to Americans and to the very foundation of our democratic process. This measure addresses the non-existent problem concerning Congress's ability to oversee and shape federal agency rulemaking. The bill mandates that Congress approve every major rule, that is, one with at least $100 million in annual economic impact, through the enactment of a joint resolution of approval before such a rule can take effect. This radical departure from current law is unnecessary given the numerous tools that Congress already has at its disposal to oversee and shape the federal agency rulemaking process. Moreover, the REINS Act's congressional approval requirement would delay and in many cases stop in its tracks the implementation of statutory mandates and the execution of duly enacted laws. Most importantly, the bill would undermine critical public health and safety protections, increase business uncertainty, create unnecessary confusion, and violate the separation of powers principles by effectively allowing one House of... This bill would undermine critical public health and safety protections, increase business uncertainty, create unnecessary confusion, and violate separation of powers principles by effectively allowing one House of Congress to veto a major rule through inaction. The REINS Act, Mr. Chairman, is simply not necessary. Congress already has numerous tools at its disposal to exert influence over agency rulemaking. One of the powers Congress has is the power of the purse. We have had no problem exercising this power to stop implementation of specific regulations that we don't like. For instance, no fewer than 19 out of the 67 amendments to H.R. 1, the full year Continuing Appropriations Act 2011, which the House passed earlier this year, were aimed at defunding the promulgation or implementation of existing and proposed regulations. We can also exercise our oversight authority, whether through formal hearings or through less formal interactions between agencies and individual members of committees. The REINS Act is also filled with unrealistic time limits. For example, under the REINS Act, Congress has only 70 legislative days to pass a joint resolution of approval through both chambers. Debate is limited to just 1 hour in the House, divided equally. Any observer of Congress knows that nothing ever happens that quickly between the two bodies, much less within one body. Committees of jurisdiction would only have 15 legislative days to consider the merits of major rules under their jurisdiction, after which a joint resolution of approval must be automatically discharged. The REINS Act would also undermine Congress's ability to consider other legislative business. For example, in calendar year 2010 alone, 94 major rules were promulgated when there were only approximately 116 legislative days when the House was in session. Even with revised expedited procedures, Congress could potentially be forced to ignore other important business at least every other Thursday doing a further disservice to the American people. H.R. 10's congressional approval requirement raises the specter of an unconstitutional one-house legislative veto because one chamber can stop a rule from taking effect simply through inaction. I note that some of my colleagues have submitted amendments, some of which, if adopted, will help temper some of the concerns with the bill, and I urge the committee to allow consideration of those amendments on the floor. H.R. 10, however, is fundamentally flawed, not just in its particulars, but in its conception. In closing, I'll say that the RAINS Act is unnecessary, and if enacted, it'll be harmful because it would undermine an agency's ability to ensure clean air and water, safe workplaces, non-toxic toys, and infant formula, and it would also impede a number of government protections from a wide range of harms. That being said, Mr. Chairman, I'll reserve any balance of my time.
Thank you very much, Mr. Johnson. Mr. Gowdy, I had indicated before you came in that without objection, any prepared statement that you have will appear in the record, and we welcome your summary. Thank you for being here.
Thank you, Mr. Chairman, for this opportunity to testify today regarding H.R. 10, the Regulations from Executive in Need of Scrutiny Act of 2011, also known as the RAINS Act. H.R. 10 was introduced, Mr. Chairman, by Mr. Davis of Kentucky and has 204 co-sponsors. Mr. Davis introduced similar legislation in the 111th Congress. The Subcommittee on Courts, Commercial and Administrative Law held 2 hearings on the RAINS Act. Mr. Chairman, earlier this year, the full committee ordered H.R. 10 favorably reported on October 24th, 2011. The President himself has talked a lot about the danger that excessive regulations pose to our economy. He's called for reviews of existing regulations and has advocated for more transparency. The President has acknowledged it is extremely important to minimize regulatory burdens and to avoid unjustified regulatory costs. Mr. Chairman, the rest of his administration doesn't seem to be following suit. This administration has adopted new major regulations at a much faster pace than its predecessors. And its current regulatory agenda calls for over 200 economically significant new rules, which typically cost the American economy $100 million or more each year. The administration also is preparing numerous regulations that each will cost the economy $1 billion or more per year. The RAINS Act strives to match the President's words with concrete action. It restores a healthy measure of congressional accountability to the regulatory process. Congress all too often, Mr. Chairman, has abdicated its responsibility to unelected executive branch entities by passing broad, sweeping ideas and leaving the details for others to bother with. It is those details that are impacting businesses and job creators. Under Article 1, Congress possesses all legislative powers granted by the Constitution, but nowadays most laws are not passed by Congress. Instead, most legislating is done either by regulatory agencies in the executive branch of the federal government or by the so-called independent agencies. In 2010, for example, Mr. Chairman, federal agencies issued over 3,300 final rules, while Congress passed and the President signed only 385 pieces of legislation. With its constitutional powers delegated away, Congress has avoided taking responsibility for some of the federal government's most difficult and controversial policy-making decisions. The RAINS Act gives the people's elected representatives in Congress, as opposed to unelected, unaccountable federal employees, the final say on whether Washington will impose major new regulations on the American economy. The Congressional Review Act, Mr. Chairman, of 1996 was an attempt to restore constitutional balance of power. Under that act, a new regulation goes into effect unless Congress passes a joint resolution of disapproval. Though well-intended, the Congressional Review Act has failed to slow the erosion of our constitutional foundation. In the 15 years since it was enacted, over 52,000 regulations, including 1,000 major rules, have been adopted by the regulatory agencies. But only 72 resolutions of disapproval have been introduced in Congress, and only one of those was adopted. 1 out of 52,000, Mr. Chairman, is almost the punchline to a joke if the issue weren't so constitutionally and economically serious. Under the RAINS Act, the major rule will not take effect unless Congress passes a joint resolution of approval. This follows the Constitution's bicameralism and presentment process as explained by the Supreme Court in INS versus Chadha. In closing, the REINS Act is a constitutional logical reform to the Congressional Review Act. It restores accountability for major rules costing $100 million or more to the people's elected representatives in Congress. A better, more transparent regulatory process will help, not hinder, our national economic recovery. I respectfully request, Mr. Chairman, the Rules Committee grant appropriate rules that will allow for expeditious consideration of H.R. 10.
Thank you very much, Mr. Gowdy. We appreciate both of your being here. As you point out, this has been an effort that's been a long time in coming, and we look forward to its consideration on the floor, and I'm hoping that we'll be able to make an order the amendments, most of the amendments that have been submitted to us. So I have no questions. Mr. Sessions.
Mr. Chairman, I really have no questions. I have a statement, and that is that I fail to believe that 204 members of this body have signed their name onto a piece of legislation that would be about dirty air, dirty water, baby formula, or other things. I think rather that 204 members of this body signed on to the bill as a result of our confidence that we could bring some balance and some better thought process to rules and regulations, and that it would be considered as feedback from this body to any regulatory agency about the impact of what their rulemaking does do. Rarely is feedback more important than at a time like this when our country is undergoing internal and external challenges as we are. And I think that I signed on to the bill, and I'm a strong supporter because I believe it's a balanced piece of legislation that we all should take heed to, and that is when you make rules and regulations and there is a job or job impact on the private sector that's involved, you at least ought to consider the value of that cost-benefit analysis. And so I want to thank both of you for being here, but I think that as one of those co-sponsors, I should not be included with the thought process that this was to diminish clean water, clean air, baby formula. I fought very hard my entire life and as a member of Congress for the rights of disabled people and for equality. And I believe that it's a well-balanced piece of legislation for people who have jobs, who take care of many of these people. And I think that self-reliance and the right of a community to support jobs should be part of what decision-making is about from regulatory bodies. And I thank both of you, and I hope I've respectfully stated my position, and I yield back my time.
Thank you, Mr. Sessions. Ms. Slaughter.
Thank you, Mr. Chair. I wanted to remind Mr. Johnson this is a good time to talk about your amendment as well while you're here.
Thank you. Ms. Slaughter, we introduced an amendment that would, since we're talking here ostensibly about protecting the ability of job creators, well, I proposed an amendment that would exempt from the strictness of this law any regulation that would actually produce jobs. And it's something that's going to promote job growth. I hope that it is held to be in order, and I hope that this body will pass it. I would like to also kind of respond just a bit to the comments of Mr. Sessions, and I certainly, by my comments, did not intend to impugn anyone's integrity or to infer that the health and safety of babies and pregnant women and that kind of thing were under attack intentionally. I don't think that was the intent of many of the co-sponsors of that bill, but I do believe that it is the impact or the effect of implementation of this law, it will definitely have the impact of putting the protection of pregnant women, children, handicapped, those, even just regular people who want to eat safe products, eat and drink safe products and food and water, and breathe clean air. It will adversely impact a federal rulemaking ability by subjecting that rulemaking process to the gridlock of politics, as evidenced by the lack of progress that this body has been able to make over the last few years on important subjects that people want us to pay attention to.
Gentlewoman yield?
Yes.
I thank my friend for yielding. Let me just say that I'm going to encourage this committee to make an order your amendment, Mr. Johnson, so that it can be considered. I thank my friend for yielding.
Thank you.
I
Ms.
think,
Fox.
I believe I have a time.
Oh, no, I mean, when you looked at me, I thought you were...
No,
Oh, you
I'd
me. I
like
thought
to.
you
I
were
just,
nodding that you were done.
I really don't have any questions either, but just some things I feel like I need to put on the record as we did last time, because we toss around a lot of terms here and things as though they were real. And I'm going to quote Republicans all the way through, people, wonderful ones. Bruce Bartlett, an economist who worked in both the Reagan and George H.W. Bush administration, said that the idea that cutting regulations will lead to significant job growth is just nonsense. It's just made up. He also said that regulatory uncertainty is a canard invented by Republicans, allows them to use current economic problems to pursue an agenda supported by the business community year in and year out. In other words, it is a simple case of political opportunism, not a serious effort to deal with high employment. And what do business owners and executives say? The data from the Bureau of Labor Statistics says that when a firm lays off workers, they are asked by the Bureau the biggest reason for the job cuts. In 2010, 0.3% of the persons who lost their jobs were let go because of government regulations or intervention. 25% were laid off because of a drop in business demand. And then our new Chief Justice, in 1980, when this same bill came before the Congress, Chief Justice, then an aide to, but now the Chief Justice of the Supreme Court, at this point was an aide to President Reagan. He criticized the same legislation for, quote, hobbling agency rulemaking by requiring affirmative congressional assent to all major agencies. Justice Roberts was right then, and he is right today. We not only put an extraordinary burden and invite all kinds of litigation, but I don't believe Congress can handle that workload. We're perfectly busy with what we're doing already, and if we have to go over everything, which the committees or the agencies are going to do as regulations, we'll have to start working here in shifts, I think. I don't know how we could possibly do that, nor should we substitute, I think, our knowledge for the engineers, the doctors, the scientists, the people who are making those decisions at the agencies. I think this is absolutely dangerous. It's kind of gamesmanship. And I think, again, as I'd said yesterday, another one-house bill or day before. So, you know, I'll be here as long as we're going to be here doing this. But it would sure be a nice day if we could come up together and do a good jobs bill. 14 million people out there looking forward to us doing it. But this has been around the block before and has been denied by many, many experts. The ones I quoted today were just the ones that we all respect from the Republican Party. So we'll follow the same thing here, I guess, and pass yet another one-house bill today. Thank you.
Ms. Fox.
Thank you, Mr. Chairman. I want to welcome you back and say we're so happy that you're...
I didn't miss you at all, Mr. Chairman.
I'm glad you're back safe and sound and represented us well. I would like to thank the two gentlemen for being here today. As I expressed briefly yesterday, I'm very supportive of the legislation that we have, the several pieces of legislation that deal with reining in regulations. I do think that it's a serious problem, and I think we can all cherry pick quotes from different people to say that's not the case, but it is a serious case. We know it. We know that most of these regulations are helping to justify a lot of bureaucratic positions and are not written simply to foster health and safety of the people of the United States. None of us want to jeopardize the health and safety of Americans. And as Mr. Sessions has so wisely pointed out, the folks who are signing on to these bills are not people who have nefarious motives. So thank you all for coming, and I have no questions.
I thank you. I just want to associate myself with the remarks of our ranking member, Mrs. Slaughter, and and just to kind of express a concern that some of us on our side have, and that is that there are members in the other party who repeatedly expressed publicly their distaste for the public sector, and so when it comes to issues like clean water and clean air, there is a concern that given the opportunity that there are some who would vote to undo what some of us think is progress, or stand in the way of what some of us think would be would be progress in terms of furthering the betterment of our environment and our health and our well-being. So I understand this is maybe kind of a nice soundbite back home, but I fail to see how this is going to create any jobs. And I'm going to repeat what I said yesterday, and Mr. Slaughter said it here today. We really need to bring the President's jobs bill to the floor. If my friends on the other side of the aisle don't want to vote for it, they don't have to vote for it. But let's have a debate on things that will get enacted, and once they're enacted, will actually stimulate economic growth. And I hope we can get to that sooner rather than later. And I have no questions.
Thank you, Mr. Chairman. And I welcome my friend from Georgia to the committee. We share a southern border, well, or a northern border, depending on which side of the border we're on down there.
And I'm glad to know that you're not thinking about putting up a fence down there.
We welcome the commerce back and forth. I hope the good people of the 4th District come and spend lots of money in the 7th on a regular basis. We welcome.
We hope the same.
I want to touch on something that Mr. Gowdy said, because it really struck me. He said, with its congressional powers delegated away in reference to what Congress has done here, you mentioned that this bill would undermine an agency's ability to get work done. And I'm thinking about what Mr. Gowdy said. This is Congress's job to get these things done. And if what the agency does is comply with the rules or comply with the intent that Congress sent that agency, why wouldn't we want Congress to come back and sign off on that before making that the regulatory law of the land?
I think that's an excellent question, and I would beg to differ. I don't believe that Congress has ceded any power to set policy. Now, traditionally and historically, it has been the agencies that, after a period of putting together a new rule, placing it out for comment from the public, including members of Congress, have the right to provide feedback on the rule. Then the rule is either adopted or it is not adopted. But that's a process that calls for a lot of expert opinion and evaluation by the powers of the agency or leaders of the agency, and that process has shown itself to work well for an untold number of years. What this legislation would do would be to severely restrict the ability of agencies to promulgate rules to towards the enactment of legislation that the House and the Senate passed, the legislature. And I think that if the legislature tries to take over rulemaking, it becomes one inefficient body. It certainly adds to the plate that we have here dealing with policy.
Well, let me ask Mr. Gowdy then, because Ms. Slaughter said something very similar to that, Ms. Johnson. She said, I wouldn't want us to substitute our knowledge for the knowledge of those experts. And I think you're absolutely right. I mean, we're counting on folks in the agencies to know exactly.
Not just the agencies, but the stakeholders have an opportunity to comment. Everybody from the general public on down to the most highly affected individual or entity with respect to that particular rule.
Well, if you know, Mr. Gowdy, as I read the bill, I can't find an opportunity for Congress to substitute its judgment. All I see is an opportunity to say this does follow congressional intent or this doesn't follow congressional intent. And if it doesn't follow congressional intent, we send it right back to those same experts to recraft it. Am I misunderstanding what the RAINS Act does?
No, Congressman Woodall, you are not. The statistics are staggering when you first contrast the number of rules that have been promulgated over the last 10 years juxtaposed with the number of laws that have been enacted. And the sad reality is Congress doesn't pass 1/10 of the laws anymore. And these rules and regulations aren't just guideposts. They are negligence per se in some instances. They are evidence of negligence in others, which is a trial lawyer's dream. There are penalties and fines associated with them. And our you can make an argument that Congress should get back all of its responsibility. You could make that constitutional argument. That's not what this bill does. It just says in major rules, when you're going through the rulemaking process and when you're writing a rule, keep in mind Congress is going to ultimately say whether or not it's implemented. It is, in the grand scheme of things, a very mild reclaiming of one's constitutional authority.
Now, I think we define major in this legislation as being $100 million worth of impact or more. In your opening statement, you mentioned that of the 52,000 plus regulations that have been promulgated in the last 10 years, what was your time frame? Do you recall?
For the past 15 years, since Congressional Review Act went into place.
And you said of those 52,000, 1,000 were major. Was that major a term of art, meaning this $100 million, or do you just mean major as in significant?
Major as a term of art.
As a term of art?
Major as falling within the purview of this bill.
So because I understand what Mr. Johnson and Ms. Slaughter are saying when they talk about the experts that are involved in this promulgation process, you're saying that the judgment of those experts would exist without any congressional approval for 51,000 of the 52,000 regulations. It would just be the largest of the large, the biggest of the big, that we say, let's just make sure that you're following congressional intent.
That's correct.
Wow. That's what, 2% of all regulations? You're right. My constituency might want us to do more than 2% of those regs, Mr. Gowdy, but that seems to be a balanced approach. Well, I'm glad my friend mentions that, because I'm looking at the amendments that were offered, and I understand what my colleague from Georgia is saying about the implementation. But as I go through the amendments, every amendment that was offered says let's exempt a category, not do any approval on it at all. Let's exempt this, let's exempt that, let's exempt another thing. There's nothing that has been offered as an amendment that says let's tighten it up because it's not going to work quite right as written. There's nothing that says 70 days is the wrong number of days, let's make it 20, or let's make it 100. There's nothing that says 15 days for committees, the wrong number of days, let's make it 5, or let's make it 30. Nothing says let's extend the time for debate or shorten the time for debate. All of the amendments say leave the process alone as you've designed it in the RAINS Act, but let's just not apply it to this, that, or the other. Is that a suggestion that the process works as designed in the RAINS Act, but it's just too expansive?
No, I think what you have laid out is pretty much an indictment of the system under which we try to enact policy. It has gotten to the point where we do not discuss legislation amongst ourselves, regardless of party, running it through the regular order of business. We don't do that like we used to. We don't have bipartisanship, and so we're not able to deal like the American people want us to deal with these important issues. And so I bemoan that fact as well. The way things work around here, it seems, is that the majority makes up its mind as to what it wants to do. It then votes in committee, in subcommittee, in committee, and then on the floor without any, or with very little deviation. The majority party, the current majority, acts with unity. Contrary to what my party does, we do not have any unity on any issue, but I can give the members of your party kudos for being united, and regardless of the merits, you're going to be united, and so that always does not work to the benefit of America.
Well, I'd like to believe it is, in fact, the merits that do unite us, and that's what takes us there. But I bemoan that partisanship, too. And in fact, one of the reasons that I am such a strong supporter of the RAINS Act is that I believe for far too long, partisanship, where whichever party is controlling Capitol Hill and that same party is controlling the White House, that kind of go along, get along mentality that thwarts the constitutional division of powers our framers laid out. You know, it's interesting that Republicans are bringing this RAINS Act to the floor. Of course, for most of my lifetime, you're more likely to have a Republican president and a Democratic Congress. So it would give the Democratic Congress the ability to override everything the Republican president is doing, or Democratic Congress the authority to override whatever the Democratic president is doing. That's of course been the congressional experience for most of modern time, because Republicans haven't controlled the House. So this is a gutsy reclaiming of authority, because odds are it's going to come back to bite a Republican administration. But it's the right thing to do, not because we're Republicans, but because we're Americans. It's the right thing to do, not because it's the agencies that are doing it, but because it's the congressional power that the Constitution gave us, for which we have the authority not just to exercise properly here, as you talked about, but to make sure we're not delegating it away. Because I know my folks are in your district. They have the power of the vote over you. Certainly 900,000 folks have the power of vote over me. I have yet to find anyone who has the power of the vote over the folks down at the agencies who are writing these regulations. And I'm enthusiastic about us having an opportunity to reclaim this constitutional mantle.
Well, if I might respond, I will say that the Constitution is the foundation of our republic, and one of the hallmarks of the Constitution is the notion of separation of powers. We give specific powers to the legislative branch in Article 1, Article 2 to the executive, and Article 3 to the judicial branch, all three branches being co-equal, and with their own responsibilities. Sometimes the task of one branch is to stay out of the purview of another branch. We've seen an erosion of that through things like judicial activism, i.e. Citizens United, and other types of impositions on congressional authority by the executive branch. And I think that each one of us should be cognizant of the care that we need to take in not eroding those functions which inure to the responsibility of each particular branch. I believe this one takes away the power of the executive branch to implement the policies of the legislative branch. And so the legislative branch, which has the policy-making responsibility, now seeks through this legislation to take the rulemaking authority, which is a presidential or an executive function.
Well,
So from that standpoint, I have to assert my, I don't think this is wise legislation.
well, while I certainly disagree with your constitutional analysis, I think both your constituents and mine would be grateful that we're using the Constitution as our guidepost here, and I wish we could use that as our guidepost for even more of what we do around here. And I yield back my time.
Much, Mr. Chairman, and that's a good segue to the questions that I would ask, and I'll start by asking, Mr. Johnson has already presented on the constitutionality, and I'd ask my good friend, Mr. Gowdy, and I might add, I really enjoyed seeing those sunny faces from your constituency today, the fifth graders, and they were bright-eyed and bushy-tailed, as we used to say. I saw Hank there just before I came out there, and it's always a rewarding experience for them to see that we do speak to each other. A lot of times folk don't think that that's true. And after I finish these questions, it might not be true either. But anyhow, I wonder, Mr. Gowdy, what you think of those thoughts regarding the fact that this may undermine the constitutional principle of separation of powers.
Well, Congressman Hastings, you beat me to it. I wanted to thank you publicly for taking time out of your schedule to come talk to a group of children that you didn't have to do it. And I had just finished telling them that despite what they see on television, we actually have very cordial relationships with folks. The question I got was, are you guys at war with each other? And Congressman Clyburn walked by, and you walked by, and Mr. Johnson walked by. It gave me a nice chance to tell children that, no, we actually like each other. So I disagree with Mr. Johnson from this standpoint. I think the purpose of the executive branch, having worked in it for 16 years, is to enforce the law. It's not to write it. And Congress, I fully admit the issues have become more complex. I fully admit that we probably couldn't survive with a part-time Congress, even though some call for it. This is a complicated world that we live in. But that, in no measure, to me, minimizes our responsibility to write the laws. And when I think of Dodd-Frank, for instance, there's a line in Dodd-Frank that says you can't take unreasonable advantage of a consumer. Well, that immediately makes me wonder, can you take reasonable advantage of a consumer? And then what is taking advantage of someone? And the issue to me then becomes, are we going to sort out those tough issues ourselves, or are we, and correspondingly let the voters pass judgment on us, or are we going to let someone who's often nameless, faceless, you're not going to hear me beat up on federal employees. I was one for 6 years. I'm not going to do that. I don't denigrate their work. I blame us for ceding our authority and responsibility to others. Would it make our jobs tougher? Yes. It might actually result in laws that people can read and understand. So that would be my response.
Would you follow that same line of reasoning as it pertains to earmarks, that we are ceding our power to the bureaucracy to undertake to tell you what's good in South Carolina and Mr. Johnson what's good in Georgia in your respective constituencies?
That argument has been made. When we got here, Congressman Woodall, Congressman Scott, Congressman Nugent, Congressman Webster, I think, are all in the freshman class. Earmarks were a thing of the past. It's funny, when you call it congressionally directed spending, you get one response. When you call it an earmark, you get another. Mm-hmm. I am sensitive to the argument that you could argue that cedes too much power to the executive branch. Mm-hmm. To not allow Congress to direct appropriations in one place or another.
Let me ask you then more pointedly, and go to the legal question and make an admission at the outset. I have not read INS versus Chandra, but I do know that it is cited often in this particular debate. And what do you think that the measure as offered here, changing the Administrative Procedure Act, which was implemented in 1946, and changing that particular measure now, and flying in the face of one veto, one House, one veto? How do you reconcile that particular decision from this particular measure as offered?
Congressman, in the interest of full disclosure, if I've ever read Chadha, it was against my will, and it would have been in law school. My recollection, and this is going back a ways, is you can't have one body or the other disapprove. It has to respect the bicameralism of Congress. Beyond that, I cannot tell you what shortcomings existed in Chadha that we seek to correct.
I feel that it, in effect, would be indistinguishable from one House legislative veto. I believe that's what the holding was in Chadha with reference to one House legislative veto. But I do want to reiterate what Ms. Slaughter said, because what we're doing here also likely will generate litigation, and conceivably could wind up at some point before the United States Supreme Court. When in 1980 we considered a nearly identical bill, the now Chief Justice of the United States Supreme Court, the eminent John Roberts, was an associate White House counsel then in the Reagan administration. And he criticized the legislation, and quoting him, for hobbling agency rulemaking by requiring affirmative congressional assent to all major rules. Justice Roberts, then counsel Roberts, said further, quoting him, "It would seem to impose excessive burdens on the regulatory agencies." And Ms. Slaughter said, and I echo her sentiments, that Justice Roberts was right then, and I believe he's right today. What say you?
I'm a big fan of Chief Justice Roberts. I wish he'd received more votes when he was being confirmed for the Supreme Court. Despite the fact that I like him, I'm not prepared to canonize him. I don't think he's perfect. Cal Sunstein, who is a highly noted professor from Harvard, has a very different perspective on whether or not overregulation destroys jobs. So I would tend to agree with Ms. Fox. We can cite folks wearing a different uniform that support our position. Whether or not something is an imposition to an agency or Congress, to me, is decidedly different from whether or not something is constitutional or not. And I full well concede it may make our days longer, it may make our jobs harder. But I think constitutionally speaking, Congress could certainly reclaim all of the authority that it has given to the NLRB or any other statutorily created. I don't know for a fact that NLRB is statutorily created, but
I claim my time just a moment to underscore what you just said, and that is it may make our days longer and may make our days harder. Will it also add time to what is already a lengthy rules-making process? In your judgment, or some estimate that it would add as much as 21 to 39 months to the rule-making process?
I don't know how it could add to the rulemaking process, because my understanding is the rule is promulgated and then Congress either approves it or doesn't approve it. And I think the way we get around the Chadha case is both parties have to, both houses have to approve it, and it has to be signed by the president. And if we don't do it, then the rule doesn't go into effect. So I I don't know how the rulemaking process would be lengthened because of the RAINS Act.
Of course.
All that up too. I don't understand the process by which we vote. Will this be the regular committee process that will go through the committees and have hearings?
I think it's a resolution, but if you would allow me to get you a more educated
I
answer.
appreciate that because I'm curious about
Vague.
how that would work.
Ma'am, I am informed that it goes to the Committee of Jurisdiction, and within 15 days, it has to be presented to the floor.
With no amendments. Well,
Yes, ma'am.
while I have the floor, too, just for the sake of the record, let me just quote what Congress can do right now and has done. We have a number of tools to evaluate, modify, or repeal regulations. Through the regular reauthorization process, the annual appropriations process, oversight hearings, investigations, directions to the Government Accountability Office, revisions of the law at any time, and entities whose activities are regulated have access to the courts. So we're covered pretty much, I think, already with the power we need for something that's excessive and bad. It just, I appreciate a lot of work has gone in on this. It's just, it seems to me that it's going to add an awful lot of cumbersome things, and I do believe invite a lot of litigation and a lot of trouble, and that we are substituting our judgment for what I think is the judgment of experts in those agencies.
Thank you, Ms.
Thank you,
Slaughter.
Ms. Hastings.
I would ask further, can either of you provide me with reliable estimates of the cost to the economy of implementing this bill?
Of implementing the RAINS Act?
Yes. Mr. Johnson, and while you're...
Just in the past 2 years, the regulations promulgated and enacted under the current administration, I've read reports that state that the positive cash benefit to the taxpayers of those regulations was about $35 billion. Now, I do not know, contrary to that, what the cost of implementation of this legislation would cost, but I would imagine the cost is going to be negative,
Yeah.
and it will be quite high. It could approach trillions of dollars. When you factor in medical costs, when you factor in we saw a failure of regulation leading to the Wall Street debacle back in 2007, which necessitated a $700 billion bailout to the financial industry, which I voted against, by the way. But nevertheless, the financial industry got the money, did what they wanted to with it, became stronger, and American taxpayers are left holding the tab. And so I would imagine, just $700 billion from the failure to regulate Wall Street is one consequence. And we're talking about removing the ability to regulate in more than just Wall Street.
Scouting?
No cost if Congress approves the rule, and CBO, despite making an effort to do so, was not able to score a repudiation or a non-approval of the rule.
Well, here's what Doug Elmendoff, the budget director, said last week before the Senate Budget Committee about different policies Congress might adopt toward these kinds of measures. He acknowledged that regulations can sometimes dampen business investment, but he concluded that changing regulations would do little to help the country in the near term. Underscore, as we always do on either side, CBO's nonpartisan, neutral posture. His quote directly from last week's testimony, in CBO's judgment, the economic effects of the specific changes in regulatory policy probably would be too small or would occur too slowly to significantly alter overall output or employment in the next 2 years, underscoring why Mr. Johnson's amendment, and I appreciate the chair saying that he was going to encourage that the committee make it in order, and I'm in agreement with that sentiment, and hopefully we will. I won't belabor you all much more, but I do need to clean up one thing that I brought out last week that I think is just as true this week as it was when we discussed this matter previously. Tom Donahoe, the president and CEO of the United States Chamber of Commerce in the year 2010, before the Des Moines Rotary Club, was giving a far-reaching speech on the regulatory state of the nation. And he cites, I believe correctly, to the Code of Federal Regulations and the significant number of pages that are spread over the significant number of volumes. But where he came down with where I was last week, and here is something that he cited to, that federal regulations are only the tip of the iceberg. There are hundreds of thousands, if not millions, of regulations at the state and local levels. In fact, those are often the ones small businesses complain about the most. And I pointed that out. I was being a lot more cavalier when I did so, but I did seek out some information to substantiate that. And I'm not putting on the side his complaints about federal regulations. I'm adding to it that many times our concerns that we address here are not the concerns of the people who have to meet the pipe fitting and have to meet the various requirements. And I have an axe to grind with my city about that, with putting in a washing machine. And I wanted to change to a measure that would be a different kind of hot water heater. And man, I would rather have seen all of the federal agencies in the world than to see that one city zoning person continue to come to my house and leave a sticker, I might add, and then I couldn't reach him by telephone. Don't begin to tell me about federal. I got a problem locally. And I understand exactly. I do believe this is a business-oriented measure and that consumers will take a hit. Thank you, Mr. Chairman.
Mr. Bishop.
Thank you for allowing me to vent for just a second with you all. One of the phrases I hate around this place is, I wish to associate myself with comments. But in this case, I wish to associate myself with the comment of Congressman Page of Virginia, who in the very first congressional session we had, when everyone wanted to go home and wanted to leave to President Washington, whom they all trusted, and rightly so, the decision of where postal routes should be, basically complained that if Congress did not stay in session and conduct the idea of determining where those postal routes would be, you might as well cede all of our decision-making authority to the executive branch and not show up at all. He was right then. The legislative function of regulation is, despite Representative Slaughter's annotated Constitution, is a legislative function. And the idea for the Founding Fathers was that people could govern themselves. It was not until the 1900s when one of our former presidents wrote an academic book about Congress having never visited the place and determined that this idea of separation of powers was, in his words, constitutional witchcraft. It was not until that period of time the idea that experts should be brought in here to alleviate all decision-making from the realm of politics that concept even started to develop here. The issue at hand is these functions are legislative, and too often our sloppy draftsmanship of legislation has allowed executive branch to impose itself in areas that should have been ours, and had we taken the time and effort to do it, would have been ours. Country of origin labeling was a great example of what was passed before I came here and was never implemented until about 8 years after I came here, because we did not take the time as the Congress to go through how you would actually do this nifty new idea that we particularly had. States, my state, for example, does have an administrative review where every rule is reviewed by the legislative branch. And if I have any complaint for your bill, is that not enough are covered in this particular branch. And I would like to have us not only have the affirmative power you're talking about here, but a negative power as well, so that every committee does look at the rest of those rules. Every rule should be reviewed by the legislative branch. That is the division of labors. That is separation of powers. That is what should be done. And I take some kind of umbrage in some of the dissenting views in which they're talking about, I think, blatant scare tactics when they say if we actually have Congress reviewing these regulations, we will undermine air pollution and water pollution and unsafe food, and then especially lead in children's toys. If I could just hit on that last one as a specific example. That particular amendment, that particular rule, has provided untold problems in the daily lives of individuals, where people who provide toys for charity bazaars or due to a second income must now take their thread to some governmental agency to prove there is no lead in their thread. It's a silly requirement. It's a requirement that applies to ATV vehicles, off-road vehicles, which would happily have an ability of exposing our kids to lead only if some kid actually sucks on the tailpipe for a long time. The rules and regulations don't have the requirement of common sense. And Congress is the body that should be responsible for that, and actually taking our responsibilities and giving them to an expert because they are an expert is an abrogation of what the Constitution told this body to do. Congressman Page was right, and this is a step going back to what Congressman Page said, and it's only a half step. I wish you'd go further. I yield back.
You know, it just seems to me common sense that if the problem is our statutes aren't tight enough, then Congress needs to draft tighter statutes. I mean, the role that Mr. Bishop articulated for this body would require substantially more staff. You know, throwing more money and more red tape and more bureaucracy at these rules doesn't make any sense to me. If you want to draft well-written laws, then we should do that. That's our job. We're Congress. Draft tight laws. And if the statutes allow for things that we didn't want them to, then we should change the statute. But, I mean, my goodness, how big do you want our staffs to be? Are they going to be 100 people, 200 people? I mean, we're going to be reading a lot of things here and voting on a lot of things that the real answer is if the law is wrong, change the law. Might take, you know, and if it needs to be defined better, we should define it better. I mean, in many cases, what I see this REINS Act is you're admitting that Congress can't draft laws. The answer is not to say that Congress cannot draft laws. It's to just draft better laws. In many cases, by the way, these laws are doing what that Congress intended when they passed them. And some people might oppose that, and maybe they didn't vote for it when those bills were passed. I mean, for people who are against some of the financial regulatory reform, I voted for it, reining in the banks, et cetera. Some of the folks that voted against that, saying, well, you know, it's not the intent, it's not the intent. Well, I mean, the intent was in the majority of the body that passed it, and you don't hear them complaining very much. In fact, there's been many letters going around to support stronger regulations to prevent future bailouts of banks and having to get the government involved with owning banks, like the Republican Secretary of Treasury and President Bush tried to nationalize the banks. You know, so again, I think it's a solution. Is there a problem? If there's a problem, we can draft better laws, and there's no doubt we should draft better laws. But you know, it's not to then try to micromanage all the implementation of the laws, which truly is what we elect a president for, and that if this body were to take on, it would have to look drastically different in terms of staff. I'll yield back.
Would the gentleman yield?
Oh, yeah, I'll yield to the gentleman from Georgia for a moment, sure.
Thank you. It's ironic that at the very time we're talking about putting more work and responsibility on Congress and congressional staffers, we have been cutting the budget for congressional offices. We are cutting that budget again this year. We cut it last year. I'm not sure what the percentage was, about 5%. And for 6 this year, I know my budget took about a $79,000 hit last year. It will take a higher hit this year. That's congressional salaries that are being cut. That's causing us to not be able to retain the kind of quality support that we need as Congress people to get the job done that we have right now. Now we're talking about giving us even more responsibility. And it seems that the design, even though it may not have been the intent, but it seems the design is to just simply do away with the rule-making apparatus and allow businesses to engage in laissez-faire capitalism.
I think the gentleman from Georgia, again, I think that Congress should tighten its belt, staff should tighten their belt. If we're asking sacrifice from the country, of course Congress should go first. But at the same time you're doing that, to add immense new responsibilities to Congress is a recipe for disaster. It's a recipe for, however poorly this was done on the executive side, to have it overseen by a understaffed and overtly political Congress is just a recipe for additional disaster, and I'll yield back.
And that is, you can have a great staff, you can run a great office, and you can do it on a lot less. I'm going to turn back $400,000 of my MRA.
Gentlemen, thank you all for being here. We appreciate your testimony.
Thank you, Mr. Chairman.
Mr. Chairman, thank you very much. I have an amendment that I would like to bring before the Rules Committee. My amendment, you may require, Mr. Chairman, I spoke on a couple weeks ago and then withdrew the amendment. It requires the agency submitting the report on proposed federal rule to include an assessment of anticipated jobs gained or lost as a result of implementation, and to specifically state whether these jobs would come from the public or private sector. This assessment will be part of the cost-benefit analysis required to be submitted to the Comptroller General, made available to each member of Congress prior to consideration of the rule. I would ask for its consideration and to be included in. I appreciate the
Any
gentleman.
questions for Mr. Sessions? I'm hoping that we'll be able to make that amendment in order. If not, that will conclude the hearing for consideration of H.R. 10, and the chair will be in receipt of a motion.
Mr. Chairman, I move the committee grant H.R. 10, the regulations from the Executive Need of Scrutiny Act of 2011, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member on the Committee on the Judiciary. Rule waives all points of order against consideration of the bill. Rule provides that the amendment in the nature of a substitute recommended by the Committee on Rules, now printed in the bill, as modified the amendment in Part A of the Rules Committee report, shall be considered as adopted. The rule provides that the bill, as amendment, shall be considered as original text for the purpose of further amendment. Rule waives all points of order against provisions of the bill as amended. The rule makes an order only those further amendments printed in Part B of the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent, and an opponent should not be considered subject to amendment and shall not be subject to demand for division of the question. Rule waives all points of order against the amendments printed in Part B of the Rules Committee report. The rule provides one motion to recommit with or without instruction.
You've heard the motion of
the rule also provides that during any recess or adjournment of not more than 3 days, if in the opinion of the Speaker, the public interest so warrants, then the Speaker or his designee, after consultation with the minority leader, may reconvene the House at any time other than that previously appointed within the limits of Clause 4, Section 5, Article 1 of the Constitution, and notify members accordingly. Finally, rule provides that Clause 3 of Rule 29 shall apply to the availability requirement for a conference report and the accompanying joint statement under Clause 8A1 of Rule 22.
You've heard the motion of the gentleman from Dallas. Let me just say that we have made most all the amendments in order that have been submitted, 5 Democratic amendments and 3 Republican amendments. The only amendments that we didn't make in order were those that were duplicative here, and so I think that most everyone who has offered proposals have seen their amendments included in the motion the gentleman has. There are 2 housekeeping items that were mentioned at the end of the rule that give the Speaker the authority to call back the House if we're in the 3-day recess, which was what we've had, and then also a provision that would make clear that printed copies of a conference report are not required if a version has been available online and has been printed in the congressional record. Obviously, we have lots and lots of paper around here, and this is a measure that says if it's going to be printed in the congressional record and made available online, that it's not necessarily to have a separate printing of a conference report. So are there any amendments to the rule?
I have one, Mr.
Ms.
Chair.
Slaughter.
I move that we report an open rule so that all members will have an opportunity to offer amendments.
Heard the
on
motion of the
floor.
gentleman from Rochester. Those in favor will say aye. Those opposed, no. The chair votes aye.
Roll call,
Clerk,
please.
call the roll.
Mr. Sessions.
No.
Mr. Sessions votes no. Ms. Fox. No. Ms. Fox votes no. Mr. Bishop. Mr. Woodall. No. Mr. Woodall votes no. Mr. Nugent. No. Mr. Nugent votes no. Mr. Scott. Mr. Webster. No. Mr. Webster votes no. Ms. Slaughter.
Aye.
Slaughter votes aye. Mr. McGovern. Aye. Mr. McGovern votes aye. Mr. Hastings. Aye. Mr. Hastings votes aye. Mr. Polis.
Aye.
Mr. Polis votes aye. Mr. Chairman.
No.
Mr. Chairman votes no.
And the clerk report the total,
4 yeas, 6 nay.
and the motion is not agreed to. There are further amendments. Ms. Slaughter.
I would like a full explanation, if I may, on the deeming. I see that we are deeming Paul Ryan, the chair of the Budget Committee's Balanced Budget and Deficit Control Act, in the rule so that the House will not have an opportunity to vote on that. Would you tell us, Ms.
Yes, ma'am.
Ryan did not come up.
If the gentleman,
To what- tell us-
gentlewoman
explain what that
yes,
does.
what we're doing is it addresses a discrete scoring issue that will allow us to continue enforcing the cut-go structure by ensuring that the costs are attributed to a bill where we can include an offset. So this is basically a housekeeping measure that allows for enforcement of the cut-go provision.
You know, it seems to me that something of that importance, though, should have been done on a separate vote, not deemed in the rule. And I think we object to that.
So would you move that we strike that?
I move that we strike that.
May I
Oh,
ask,
sure.
see, that's a $100 million housekeeping.
It's for the enforcement of cut-go, as I said.
If I could ask a question, is it germane, or do we waive germaneness rules on this, too? My understanding is the parliamentarian said it's not germane.
Yeah, it falls within the jurisdiction of the Budget Committee.
So it's not germane.
So we are waiving the
Yeah,
germane requirement. to make this
and
order.
I just raised that issue because on Tuesday, you were not here, Mr. Chairman, but on Tuesday, we had the majority here blocked my amendment to end taxpayer giveaways to big oil companies, and I was told because it was not germane and no one wanted to waive germaneness rules, but something must have changed since Tuesday, because here we are with a rule that not only waives the germaneness rule for the Ryan amendment, but it deems it passed without a vote on the House floor. So I'm hoping
There is a distinct difference here. This is a measure that is emerged from the Budget Committee. This is not an amendment that is going to the floor. And so that's because of the fact that it has emanated from the chairman of the Budget Committee for the enforcement of cut-go, that's the reason.
So if I had offered my amendment to end oil subsidies for taxpayer-funded oil subsidies, and I asked that it be deemed passed, so we didn't have to have it for a vote on the floor.
Is this something that's been reported out of committee? Is this something that is
Yeah,
the committee's dealt with?
So-
I don't know. Has another committee dealt with this issue that you're referring to?
Why wouldn't we have a vote on this on the floor?
Yeah. This is reported from the chairman of the Budget.
No, it was not reported on the committee.
Reported from the chairman The Budget Committee.
Well,
He's
so-
the chairman of the Budget.
Without
So it's
any,
reported-
without any committee action.
So the chairman of the Budget Committee gave it to you, but it was not reported from the Budget Committee.
Right, it came from the Budget Committee chairman, and this deals with the enforcement of cut-go. So you
This all
moved that we
takes my
strike
breath
this.
away.
Let me move that we strike.
The vote occurs on the Slaughter amendment. Those in favor will say aye.
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 Those opposed, no. No. Opinion of the chair, the noes, independent chair, the
Roll call,
noes have it.
please.
Clerk, call the roll.
For Jim, who didn't get his amendment.
Mr. Sessions?
No.
Mr. Sessions votes no. Ms. Fox? No. Ms. Fox votes no. Mr. Bishop? Mr. Woodall? No. Mr. Woodall votes no. Mr. Nugent? No. Mr. Nugent votes no. Mr. Scott? Mr. Webster? No. Mr. Webster votes no. Ms. Slaughter?
Aye.
Slaughter votes aye. Mr. McGovern?
Aye.
Mr. McGovern votes aye. Mr. Hastings? Mr. Hastings votes aye. Mr. Polis?
Aye.
Mr. Polis votes aye. Mr. Chairman?
No.
Chairman votes no.
And the clerk reports the total,
4 yea, 6 nay.
and the amendment is not agreed. Are there further amendments?
Yes.
Mr. McGovern.
It's a very interesting rule. Mr. Chairman, I have an amendment to the rule. I move to add 2 sections to the rule. The first would require that the clerk of the House to notify members of the date and time at which a measure was made publicly available. The second would require the clerk to establish a procedure to notify members whenever a measure is made publicly available. And if I just have a minute to explain this. The rule that you have proposed contains a new section that modifies the requirements for the availability of conference reports to the public. Now, I understand why you're making this change, but since you're suggesting modifications in the notification process, I would like to suggest 2 additional improvements. My amendment is designed to correct 2 deficiencies in the current practice. First of all, the Rules Committee majority website does not disclose the date and time when bills are posted. For example, if you go to the committee website today and look up any legislative language, you cannot tell whether it has been available for 6 months or 6 minutes. There is no reason why members of the House and the American public should not be able to find out how long a bill has been available. Therefore, the first section of my amendment requires that the time and date of the posting be disclosed alongside the text of itself. Second, members of the House have no way of knowing in real time that new legislation has been posted. This is particularly important when text that has not been considered by any committee is posted late at night or over the weekend, as often happens. The second section of my amendment requires that members of the House be notified at the time when new legislation is posted. Mr. Chairman, there should be no, I don't think any disagreement about these 2 simple proposals, disclosure and notification, and I would urge my colleagues to support my amendment.
Let me say that I thank the gentleman for his very thoughtful suggestions, and I completely concur with the notion behind what it is that he's attempting to do. We've actually been working to ensure that our text is available for 3 days, and we're clear when our website is updated to continue to do that. Most of the issues that the gentleman has raised will be addressed as required by the House rules. The clerk's page for electronic text comes online after the first of the year, and so the goals that the gentleman has, I believe, are a work in progress right now and are underway. And I'll say that in the next few weeks, I'm going to encourage a no vote on this amendment, but I'll say that in the next few weeks we'll make it clear on our own website when pages are originally posted and updated, in addition to our practice of showing the date and time of items added to the website. So I'm going to encourage a no vote. The vote occurs on the McGovern amendment. Those in favor will say aye.
Aye.
Those opposed, no. Opinion of the chair, the noes have it. Clerk, call the roll.
Mr. Sessions?
No.
Mr. Sessions votes no. Ms. Fox? No. Ms. Fox votes no. Mr. Bishop? Mr. Woodall? No. Mr. Woodall votes no. Mr. Nugent? No. Mr. Nugent votes no. Mr. Scott? Mr. Webster? No. Mr. Webster votes no. Ms. Slaughter?
Aye.
Ms. Slaughter votes aye. Mr. McGovern?
Aye.
Mr. McGovern votes aye. Mr. Hastings?
Mr. Chairman, at the conclusion of the vote, before we recess, I'd like to raise a matter with the
Well, we
chair.
of course
if I
have a
may.
chance to do that. We're in the middle of a recorded vote.
I just
right now.
said at the conclusion.
Yeah, I know. I mean, that's assumed.
Yes.
I'm not going to cut anybody off. Don't worry. We still got efforts to make care.
And I vote
Mr.
aye.
Hastings?
Gentleman votes aye.
Mr. Hastings votes aye. Mr. Polis?
Aye.
Mr. Polis votes aye. Mr. Chairman?
No.
Chairman votes no.
Clerk report the total,
4 yea, 6 nay.
and the amendment is not agreed to. Mr. Hastings.
Yes, sir, Mr. Chairman. I was not suggesting that you were going to cut me off.
No, I
I
just
just
we were in
wanted
the
to
middle of
alert the
recorded
chair
vote,
that
so
I did have a question. Yeah, but no problem. In the spirit of what we have just done, Some of you may have noticed that I have put on our little box, don't put these papers in here. My complaint about that is that we don't get around to those papers, and so I have two, they're not really questions, it's suggestions, that we get on with the business of what is going to be needed, particularly for our committee, and that is that we have computerized electronic information here at our respective stations here in the Rules Committee. I don't think it would require as much as people might think. I saw evidence of this, and I'm sure the chair is aware, in the Intelligence Committee. We were able to rapidly access information without having to involve all of the paper. Most people do just like I do. They go out here, they take that paper, and they throw it in the garbage. We could save 2 trees anyhow.
No, I mean, I obviously concur. I mean, anything that I think that's what we've just done. One of the amendments here, one of the measures included in this bill is to say that we don't require another printing of conference reports when they're made available online and included in the congressional records. So any recommendations that can help us in this quest, I think, are very important. There are further amendments? If not, the vote occurs on the motion of the gentleman from Dallas. Those in favor will say aye. Those opposed, no.
No.
The ayes have it.
Roll call,
Clerk, call the roll.
Mr. Sessions.
Aye.
Mr. Sessions votes aye. Ms. Fox.
Aye.
Ms. Fox votes aye. Mr. Bishop. Mr. Woodall. Mr. Woodall votes aye. Mr. Nugent. Mr. Nugent votes aye. Mr. Scott. Mr. Webster. Mr. Webster votes aye. Ms. Slaughter.
No.
Slaughter votes no. Mr. McGovern.
No.
Mr. McGovern votes no. Mr. Hastings. No. Mr. Hastings votes no. Mr. Polis. No. Mr. Polis votes no. Mr. Chairman.
Aye.
Chairman votes aye.
The clerk report the total.
6 ayes, 4 noes.
And the motion is agreed to, and for the majority, Mr. Woodall will be managing. Oh, it says Mr. Woodall right here. Okay, excuse me. Mr. Nugent will be managing for the majority, and Ms. Slaughter for the minority. Thank you all very much. We'll be meeting sometime. Yeah. This is going to be on the floor next week. Yeah, next. That's the plan. Yeah, that's the plan for right now. Thank you all very much. Without objection, the committee stands adjourned.